friends, and welcome to another WSIB Truth Matters with Joe Machado. I'm excited to share with you my fourth video on the topic of tribunal jurisprudence. That's workplace safety and insurance tribunal jurisprudence. A lot of tribunals have jurisprudence throughout Canada. Different tribunals. This one is with respect to the Workplace Safety and Insurance Appeals Tribunal. Thought I would just say that for those of you who are new and you're just watching for the first time. If you're not familiar with what jurisprudence is, I recommend that you watch my video last week when I launched this 5-part series talking about jurisprudence and how valuable a tool it is for both injured workers who are claiming benefits or appealing decisions, or even paralegals and lawyers representing injured workers. It's a very useful tool, and I just thought that I would share this with you. My 5-part series talks about 5 distinctive areas of jurisprudence that deal with specific issues. Today's video, I'm going to talk about secondary condition as being causally related to the injury, and then sequential issue. And so basically what that means is that the tribunal has jurisdiction to hear all WSIB appeals, providing they've gone through the WSIB appeal system, which I have no confidence in for many, many reasons. And then it goes to the tribunal. The tribunal is the last level of appeal. And the tribunal has jurisdiction to overrule the WSIB. And so the issue of secondary condition and sequential issue could be of interest to a lot of you if you've had an injury and then you developed a secondary condition relating to that injury. So I'm going to give you some examples of that as we go through the video. So the decision that I'm going to talk about for this presentation, it's WSIAT decision number 259//23. I'm going to put it up in the screen, so don't worry about writing it down now. And then you'll be able to download it and refer to it if you want to really get familiarized with the decision and the different aspects of the decision that may apply in your particular case. This decision was rendered on June the 16th, 2023. So it is relatively new. And so I like to try and get decisions that are as close to the present as possible, just to show the stark contrast that still exists between how the WSIB case managers and appeals resolution officers and the Workplace Safety and Insurance Appeals Tribunal. The tribunal is very thorough. I have a lot of confidence in the tribunal. Over my last 30 years of dealing with WSIB on a professional level, with over 10,000 clients all over the province, I've gotten a chance to see a lot of stuff, and a lot of it I don't agree with. So anyway, we'll get into this presentation here. So this gentleman was going for entitlement for a right shoulder condition, and he was claiming that it was causally related to his left shoulder condition, which is compensable. So the left shoulder was accepted in his claim, and he's looking for secondary entitlement for the right shoulder. Now, there are a lot of instances where the support required to have an injury or something that develops as a result of the main injury being accepted in a claim. There are factors that support it, others don't. But these are things that are normally assessed through the description of the injury, or the type of work the person did, how the compensable condition came about, and then how the secondary condition developed. And so being able to tie that all together is important. And a lot of it has to do with medical. So just a little bit of background on this one here. So this gentleman started working for the accident employer in September of 2019. He was working as a butcher. The injury occurred in September of 2019. He was working as a butcher, but he'd been working with the accident employer for 25 years. So on the day of the injury, he was operating a rider pallet in a refrigerated warehouse. A second jack collided with his rider jack, and his right foot was crushed and trapped between the two pallets. The worker eventually pulled his foot loose by leaving the boot stuck and removing just his foot. When he tried to stand up, his right foot gave up. He fell, and as he fell, he injured his left shoulder. So there's no dispute as to entitlement to the left shoulder and entitlement to his left foot. He was then later assessed and was given a 2% non-economic loss award for his left foot and a 15% for psychotraumatic disability, which was eventually accepted in the claim. He did have a lot of issues that resulted and developed from this injury. He began to have difficulties with his right shoulder, and I'm going to put up on the screen here just some of the elements from the decision that cover the issues when the medical when the problem with the right shoulder began to develop. So on the screen here, Dr. Timorak and Dr. Armstrong attributed the right shoulder injuries to compensation for the left shoulder. Altum upper extremity took no position on causation. This is where he was treated. The proximity of the worker developing right shoulder symptoms after returning to modified duties using only his right arm is suggestive of a causal connection. The modified work in the laundry area included frequent repetitive reaching with his right arm, including some upward reaching. This was physical, repetitive work that exerted wear and tear on his right shoulder. The worker is entitled, after reviewing the medical extensively, they concluded the worker is entitled to benefits for right shoulder injuries as a secondary condition caused by the compensable left shoulder injury. So now that they've ruled on entitlement for the right shoulder as being causally related to the left shoulder, and they've accepted into the claim, this is where they now have jurisdiction to deal with this sequential issue, which is the matter of whether or not the shoulder or the right shoulder has developed into a permanent impairment. So one issue is the secondary entitlement. That's not a sequential issue. It was appealed and went through the process, but the sequential issue becomes the tribunal accepting entitlement for the condition, and now they're looking at the permanent impairment for the condition. So I'm going to put it up on the screen here, friends. So the tribunal has jurisdiction over final decisions of the board. A final decision of the board ought to be construed broadly and purposefully to determine the scope of the tribunal's jurisdiction. The tribunal has jurisdiction to address sequential issues, those being issues that arise out of entitlement. See, for example, decision number 1998/19R 2020 and another 2071. Given that the board denied entitlement for the right shoulder injury, there was no scope for the worker to pursue any sequential issues after that. If the board had allowed entitlement to benefits for the right the worker's right shoulder injury, the board could have then addressed the sequential question of a right shoulder permanent impairment. Without entitlement in place for his right shoulder, the worker was unable to pursue the sequential issue of right shoulder permanent impairment. Although the tribunal is not required to address sequential issues, the tribunal may do so, such as in situations where the proceedings and questions are not complicated and the evidence is sufficient to make the determination. In particular, we note the strong medical evidence of ongoing impairment of the right shoulder, which they obviously used to accept the right shoulder as a secondary condition. They go on, Dr. Armstrong treated the worker's bilateral shoulders in June of 2020. Dr. Armstrong prescribed physiotherapy for the bilateral shoulders. The acupuncture and chiropractic care mentioned above was also for the bilateral shoulders. The lifting, pushing, and pulling restrictions provided by Altum lower extremity on September 10, 2020 were applicable bilaterally. And so the board went on to allow entitlement for a permanent impairment for the right shoulder. But it doesn't stop there. Now that they've allowed entitlement to the right shoulder and they've allowed entitlement on a permanent basis, then it opens up the door to look at what other benefits flow from this decision that the tribunal has the jurisdiction to review and consider in their appeal. And that is the issue of loss of earnings benefits. So his benefits obviously had been affected by the WSIB not having accepted the right shoulder into the claim, the right shoulder permanent impairment. But now with the WSIB's review of this matter, they can deal with any loss of earnings entitlement, which is another sequential issue derived from the entitlement to the secondary issue. So the scope of entitlement, I'm going to put it up on the screen here, and how they deal with the issue of LOE. So regarding the sequential issue of loss of earnings benefits, we note the clear evidence that the worker has experienced a wage loss due to his compensable injuries. The worker previously held a Class 1 position for a few months when he started working for the employer in 1994. Then he joined the union and became a Class 4 relief man, butcher, a position he held for 25 years. He was also frequently stepped up to the lead hand Class 5 position, receiving extra pay whenever he stepped up to lead hand. There's about a $5 per hour wage difference between the Class 1 and Class 4 positions. The lead hand Class 5 position was paid about $2 more per hour than a Class 4 position. Before the accident, the worker worked about 11.5 hours per shift for a total hours about 60 hours per week. He also worked as a part-time pizza delivery driver and had another part-time job doing maintenance at his church. Post-accident, the worker no longer does his part-time jobs. He still works for the employer. However, since the accident, he has never returned to his regular duties. Now the worker is considered a Class 1 worker. A Class 1 worker is a beginner-level worker earning minimum wage. The worker's change in position and inability to return to being a relief man butcher is due to his compensable injuries. As a Class 1 worker, unable to do his additional part-time jobs, the worker clearly has a loss of income. We find that the worker is entitled to partial loss of earnings benefits, the particulars of which we remit to the board. So basically, the board then has to review the matter and ensure that the worker is appropriately compensated for the partial loss of earnings between the Class 4 butcher, the Class 1 butcher, and the one lead hand which he occasionally had, which I believe came to about $6 an hour. That's a lot of money. But none of this would have happened unless the tribunal had granted entitlement to the right shoulder as a secondary condition which then opened up the door and jurisdiction for them to deal with the right entitlement for the right shoulder, permanent impairment for the right shoulder, and loss of earnings benefits that have resulted as a result of that the right shoulder being part of the claim. So I hope this was able to help some of you who may have similar situations such as this one. There are many issues that are where there's tribunal jurisprudence that can be very, very helpful in putting together an argument for entitlement or going to an appeal. With my firm, WSIBsettlements.com, we have our settlement docs, which are documents that were prepared by me with over 30 years of experience of dealing with the Workplace Safety and Insurance Appeals Tribunal, having built the largest paralegal firm in Ontario with over 10,000 clients and over $300 million in settlements, both in arrears and future benefits. And the reason why I say this is not to brag, but just to give you an idea that my firm handled a wide range of issues over 30 years, dealing with issues anywhere from pre-1990 claims to Bill 162 claims and Bill 99 claims, and a variety of legal issues and policy issues relating to those various legislations. So there's a series of tools that I've also developed through WSIBsettlements.com to help injured workers manage their claims and get the benefit or the maximum benefit that you're entitled to under the law. So I welcome you to have a look at WSIBsettlements.com and see if it's something that can be helpful for you. There's no obligation whatsoever. If you find the information I'm providing here can be of help to you, then I'm very happy that you can use it. I started this YouTube channel about 4 months ago. I have a mission to provide videos on a wide range of topics to help injured workers all over the province. There's a lot of remote areas, and there's a lot of people out there who are injured in the job. They don't know what their rights are. They're looking for somebody or an organization that can help them. Going to a lawyer and a paralegal can be very expensive. You may have to give up a lot of your settlement. So basically all I did was provide an alternative. So I welcome you to do that. If you're not already a subscriber to my channel, I invite you to become a subscriber. It costs you absolutely nothing. Just click the subscriber button and you get notified every time I come out with a new video. It helps me to build the channel, to get more exposure, and to have more people across the province tune in to my videos. I think I'm up to 74 videos now in about 4 months. And I've got, like I said, over 30 years of experience in dealing with the WSIB. I'm also an injured worker, so I understand. I understand what it's like to go through what you're going through now. Believe me, I do, and I know how intimidating dealing with the WSIB is. I'm not intimidated by them in the least. They hate me. I'm the one person in the world that they loathe, and the feeling is mutual. But I don't give a shit what they think about me. Bottom line is I'm here to help injured workers, and if I can help you, then I'm happy with that. And please share my videos with others if you have any other questions, specifically relating to the subject matter that you may not necessarily want to deal with in the comments. By all means, send me an email at joemachado@WSIBsettlements.com. Give me some of your details and I'll get back to you with some direction. And please share my videos with others. I really appreciate that. And coming up tomorrow, so the fifth video of this topic. I hope that you found this interesting. Those of you who've watched the three videos and this one coming up now, and I look forward to putting out the next one tomorrow. The next one is loss of earnings, arrears, employability, and suitable occupation, and jurisprudence on this particular matter, and how the tribunal deals with these issues. As you know, that the WSIB uses deeming practices to really screw over injured workers in the worst way. And for those of you who've had a FEL or an LOE that was based on a fictitious SEB, something they pulled out of the hat, and earnings that are probably not realistic, then I really encourage you to watch this next video. So, as always, friends, thank you for taking the time to watch this video, and please share my videos. As always, take care now.